in the penalty notice, it said you could fill out a waiver form, and I contacted the finance department, got the proper waiver form, filled it out. That form had a reference to a section of the Virginia Code, 58.1, 3916, the famous 3916, which said in critical part, no penalty shall be assessed when the failure to make timely payment is not the fault of the taxpayer. And that's what always and ever came down to.
Mm-hmm.
We thought myself and the neighbors thought there was ample evidence that this is not our fault, and therefore the statute didn't just say may not be assessed or might not be assessed if the city determines. It says shall not be assessed. It was a prohibition. And I laid all that out in my appeal form, and the attached detailed statement and the email that I used to send it to them didn't do any good. And in December, again before you were here, they just your appeal is denied. Okay. And if you have problems with the mail or something, you can go online. Now, I didn't think that was right, and I talked with and worked with the neighbors, and we identified the 20 affected ones. They all said they hadn't gotten them. So I started contacting. I emailed our city councilman, Andreas Addison. I contacted the Inspector General's office of the Post Office Department to confirm that there are, or were at that time, perhaps they've corrected them, but you've seen in your own paper a lot of stories about the continuing widespread problems with postal delivery. I spoke to the Congressional office. I spoke to Commonwealth Attorney McKeechan's office, all to try to find some way into this in addition to the city, given the federal and local nature of the problem, to see if I couldn't identify some other agency that would sort of point out to the city, help the city understand that this is not our fault and the penalty should be repaid. None of that outreach generated the solution to this. I mean, City Council, CA's office, Congressional office, Senator Kane's office, people were expressed sympathy, or they just said you need to pursue this with the city, the finance department. There was no solution in any of that. So I continue to think, as a retired attorney, that the city was wrong, and so they say in the denial letter you can go to circuit court. So I began to prepare to go to circuit court, take them to court. And I'm retired, so I couldn't actually file the papers, so I needed to find an attorney to work with. And I was fortunate, after some looking around, to connect with a guy named Shane, S-H-A-N-E Smith, at Williams Mullen. Just a first-rate, I'd never met him before, first-rate person, first-rate lawyer. So he and I were going to work together on the litigation.
Mm-hmm.
And so I kept conveying to the city, I'm coming. I'm going to do this. I have a different view of the controlling statute. I think they're wrong, and I think you're wrong, and I'm prepared to go to court. And as a result of those continuing communications, the issue finally got elevated to Mr. Saunders, Lincoln Saunders, the chief administrative officer,
Mm-hmm.
and the person in the city government who finally responded, finally focused on this, and I guess finally understood that it was the right thing and in the city's interest to settle this and repay the penalties,
Yeah.
and not go to court, because I think we would have won. We've taken up a collection in the neighborhood to pay Shane Smith, and we were serious, and the city understood we were serious, and like a lot of people and organizations threatened with litigation, they assessed the pros and cons and the merits of the claim against them, and apparently they well, more than apparently, they changed their position.